Everybody is requested to please settle down. Respected guests, we will now commence with our last session for the day on international law, selective compliance in a multipolar world. Ms. Maham Naveed, moderator for the session, is kindly requested to take her seat on the stage. I would now like to request the speakers for the session, Professor Mbengue, Faculty of Law, University of Geneva, Switzerland, and Mr. Ahmed Bilal Soofi, Founder, Research Society of International Law, to please come on the stage. Our moderator for the session, Ms. Maham Naveed, is an international lawyer and holds a master's degree in law from Yale Law School. Previously, she was working as a consultant at the International Dispute Unit of the Office of the Attorney General for Pakistan. She has been a part of the team that has represented the federal government of Pakistan in historic international legal cases, including Reko arbitration, Indus water dispute cases, and national security issues. She has also worked at the Paris office of the international law firm Sherman and Sterling. Her areas of expertise include public international law, particularly international human rights law, laws of conflict, and national security laws. I hand over the floor to Ms. Maham for session's proceedings.
Thank you, Tanzila, and good evening, everyone. And thank you for being patient and bearing with us till our last session. So, our panel on international law today will delve into a very critical issue facing our global society: selective compliance with international law in an increasingly multipolar world. As we navigate through a landscape where power dynamics shift between nations, the question arises: how do we uphold the rule of law internationally when adherence to the law varies so significantly amongst states? International law, in its modern form, evolved during the colonial era. As a result, global South countries often correctly view parts of the international legal order as rooted in colonial structures that still disproportionately favor the global North. This historical context influences their skepticism towards certain international norms and has driven calls for reform of the current legal order. International law was designed to foster cooperation, promote peace, and protect human rights. However, in a multipolar world, compliance with international law remains a contested issue. On the international stage, countries often choose which laws to follow based on overlapping determinants such as national interest, diplomatic agendas, geopolitical alignments, and enforcement mechanisms, or the lack thereof. As an example of selective compliance, in matters of human rights, countries may champion human rights on the global stage, yet fail to uphold these norms domestically. This hypocrisy fosters cynicism and disengagement from international norms, making accountability an issue. The ongoing genocide in Palestine and Israel's complete disregard of international law and international courts is testament to the gravity of the issue under discussion today. Similarly, the Russia-Ukraine war and the massive human rights abuses in Indian illegal occupied Jammu and Kashmir have also expressed the discrepancies in international law when it comes to matters of compliance. Climate change is yet another slippery slope. While many nations pledge to reduce carbon emissions, some major polluters fail to meet their commitments internationally. When powerful states prioritize their economic development over collective environmental responsibility, the consequences ripple through the entire international community. Calls for reform are thus growing, aiming to create a system where international laws are developed with the participation of all states, respecting diverse perspectives, needs, and historical contexts. For an inclusive international legal system, it is crucial to address these disparities, enhance representation, and respect the developmental priorities of the Global South. This shift would ideally lead to a more equitable framework that acknowledges past injustices and fosters a shared commitment to global peace, security, and sustainable development. With this background, today's forum is focused on exploring ways in which the international community can understand and navigate issues of compliance within a system based on sovereign equality and consent. Our panel today comprises of two renowned international lawyers, both of whom have advocated for a stronger relationship between the Global South and the development of international law. We have with us Professor Mbengue, who is a professor of international law at the University of Geneva and director of the Department of International Law and International Organization. He is also the president of the African Society of International Law. Professor acts as an international law expert for multiple international organizations, including the African Union, the World Health Organization, the World Bank, and the International Labour Organization, amongst others. Professor Mbengue has also acted as counsel in disputes before international courts and tribunals, Notably, he has served as legal expert for the African Union in advisory proceedings before the International Court of Justice on the legal status of Israel's occupation of the Palestinian territories. Thank you, Professor, for joining us today. We also have with us Mr. Ahmed Bilal Soofi. Mr. Soofi is a renowned international lawyer and former Federal Law Minister of Pakistan in the caretaker setup. He is currently a member of the ICC Court of Arbitration. Mr. Soofi regularly advises the government on international treaties, international sanctions, UNSC resolutions, and bilateral and multilateral issues pertaining to public and private international law. He has represented Pakistan before the International Court of Justice and other international judicial fora. He has also chaired the Advisory Council of Human Rights in Geneva. Mr. Soofi is the founding partner of the globally ranked law firm ABS & Co. He is also the founder of the Research Society of International Law, Pakistan's first think tank dedicated to the research and development of international law in Pakistan. Thank you, sir, for joining us today. I now invite Professor Mbengue for his opening remarks on the global implications of selective compliance by the North. Thank you, Professor.
Excellencies, distinguished colleagues, distinguished guests, dear colleagues and friends, ladies and gentlemen, salam alaikum wa rahmatullah. It's a great honor and privilege for me to be here today in the beautiful city of Islamabad. And I would like to thank very much IPRI for the invitation, and also would like to warmly thank the government of Pakistan for the hospitality and the facilitation of my trip here to Islamabad. It's my first time in Pakistan, and I can tell you that it's a dream come true. I've been all over the planet, and Pakistan was one of the countries that was staying a bit mysterious to me, so I'm very happy to be here. Thank you. So I've been asked to share some few observations, thoughts on the global implications of selective compliance by the West. I think that this is a very fascinating topic in light of the current challenges that the international community is facing. So the title that I have is like an equation. It's what mathematicians would call an equation, and as you know, in any equation you have terms. And in my equation there are two terms. The first one is selective compliance by the West, and the second one is the global implications of that selective compliance. So let me start with the first term. What do we mean by selective compliance by the West? Quite often, there is a tendency to reduce selective compliance to lack of compliance. That's the easy way, the very simplistic manner to describe selective compliance, to reduce it to lack of compliance. In reality, what we mean by selective compliance is much more complex. It's much more subtle. And when you look at the conduct, at the behavior of the so-called global North or Western world in relation to international law, you can actually determine that there are different facets of what is selective compliance. I even like to call them the different shades of selective compliance. And for me, there are 10 shades of selective compliance. And I would like to share those shades with you. Shade number one, selective compliance means international law à la carte. I'm using a bit of French, but it is a French that is also accepted in the Anglophone world. International law à la carte. You know à la carte? When you go to a restaurant, you have la carte, where you have a menu where you can choose between different options. And so selective compliance, when it comes to international law today in the Western world, is first and foremost about international law à la carte, some picking and choosing by countries on what they believe is the applicable international law and what is not the applicable international law. So it's basically subjecting international law into a cherry-picking process. I was very recently, I was involved in discussions regarding the application of international law to the cyberspace. We've been talking in some of the previous panels about artificial intelligence, about new information technologies, and what they may imply for legal systems. And right now, there's a lot of discussions within the United Nations on what is the applicable international law when it comes to cyberspace, when it comes to cyber attacks, when it comes to new information technologies. And as you can imagine, these are new fields of international law that were not traditionally governed by the corpus of existing rules and principles of international law. And so when you go to those discussions and you listen carefully to the statements that are made by Western countries regarding the application of international law, what you see is that they try basically to reinvent international laws through the prism or the lens of cyberspace. So they take advantage of discussions on cyberspace to actually question or sometimes even reject the existence of certain fundamental principles of international law. So you have, for instance, states that have taken advantages of discussions on cyberspace to question whether due diligence is a principle of international law. And some of those Western states, the US, the UK, claim that due diligence is actually not part of international law. When we all know, those of us who have studied international law, that it's maybe one of the core principle, elementary principle of the international legal system. So this is the first facet, the first shade of that selective compliance, the international law a la carte. Shade number 2, what I would call differentiation-based international law. Differentiation-based international law. Today, we have some narratives coming from the West that consist in basically giving some sort of immunity to certain states when it comes to the application of international law. Immunity was never supposed to cover application of international law. Immunity is here to protect states from the domestic jurisdiction of other states. Immunities are here to protect states from having their assets being seized. But immunity in the application of international law, I never heard. So today, selective compliance is about developing that type of narratives where certain states, for some very mysterious reasons, would benefit from an immunity when it comes to the application of international law. International law should not apply to them and should not apply to their leaders. This is what I call the differentiation-based international laws. Some others would maybe even call it discrimination-based international law. You know, just think about the reaction of certain Western states when the ICC issued arrest warrants against Mr. Netanyahu. The previous government of the United Kingdom, not the new one, the previous government of the United Kingdom was preparing a memorandum that they would submit to the ICC to explain to the ICC why they cannot issue an arrest warrant against Mr. Netanyahu. So it was not Israel preparing such a memorandum, it was the United Kingdom preparing such a memorandum. Think also about the reaction of Germany when South Africa filed a case against Israel before the International Court of Justice on the basis of allegations of genocide. You have right now a pending case before the International Court of Justice brought by South Africa against Israel. South Africa is accusing Israel of committing a crime of genocide in Gaza. The reaction of the German government, 1-2 weeks after that case was filed, was to say, we will intervene in the case to prove that the allegations of South Africa are wrong. This is something that was never seen before. A state intervening in a case before the International Court of Justice to actually counter an applicant, counter the allegations of an applicant. So this is what I call the differentiation-based international law, this new narrative according to which whenever we invoke the opposability of international law to certain states, Western countries would actually serve as a shield in protection of those countries. That's the second shade. Shade number 3, that is maybe the most famous one when it comes to selective compliance. Double standards-based international law. I say the most famous because even those who are not international lawyers, today, quite often when they think about selective compliance, they see it in terms of double standards. So double standards is different from differentiation-based international law. Double standards means what? Double standards-based international law means that for two similar situations, you have different application, different interpretation of the rules. So you are not really rejecting the application of the rules like in the differentiation-based approach, but for similar situation, Western countries would come with different interpretation and different application of the rules of international law. And I think that I don't even need to be detailed about that. Just think about how the Russian military, special military operation in Ukraine was treated by the international community, and how the war in Gaza by Israel and now in Lebanon is treated by the international community. So you have two similar situations where the international community, where you could think that there is some sort of aggression, but with two different responses, two different treatments from Western countries. When it comes to Russia, the emphasis is on the need to comply with international law. And when it comes to Israel, there's simply no discussion of the need to comply with international law. There's just a reinterpretation of the rules of international law that would allow what is happening in Gaza to happen. So this is what we call the double standards based international law, which is another facet, another shade of the selective compliance by Western countries. Shade number 4, self-judging international law. That's the fourth facet of the selective compliance, self-judging approach to international law. What do I mean by self-judging? Well, you have today new narratives in the Western world that consist in considering that powerful countries, Western countries, can basically unilaterally determine the content of international law, and that such a determination of the content of international law should not be subject to any international scrutiny, should not be subject to any international supervision, should not be subject to any international control, that it has to be self-judging. And that's another facet, another manifestation of selective compliance, when states believe that their interpretation of international law is self-sufficient, self-contained, and self-explanatory without having to subject it to any control or any supervision. And we've been seeing that, for instance, during the first Trump administration, and I think it will come back to that, where in the name of national security, the US administration would simply come with very unilateral interpretations of international law that the US administration believes should not be subject to any international control, to any international supervision, not even subject to dispute before international courts and tribunals. And that's the reason why the Trump administration, for instance, withdrew from many international treaties, because they just wanted to push forward this self-judging approach to international law. So selective compliance is a result of self-judging approach to international law. Shade number 5, facet number 5 of selective compliance, what I would call power-based international legal system. Not rule-based international legal system, but a power-based international legal system. We are witnessing that. A movement, a shift from a rule-based system to a power-based system, where powerful states in the Western world, in the global north, consider that they are the own judges, they are the sole judges of the time and the space of international law, what I would call the time and the space of international law. The time of application of international law, the space of application of international law, and all that not on the basis of rules, but on the basis of power. Think about issues of decolonization, for instance. We in Africa, we've been having an issue in the last few years, which was about the decolonization of Mauritius. When Mauritius was granted independence in the 1960s by the United Kingdom, the UK detached an archipelago from Mauritius, turned that archipelago that is called Chagos, turned it into the British Indian Ocean Territory, and decided that it was its territory and not the territory of Mauritius. And so when Mauritius was successful in having a majority of the UN General Assembly requesting an advisory opinion to the International Court of Justice on its decolonization process, the International Court of Justice was very clear on the fact that the administration of the Chagos archipelago by the UK was contrary to international law, and that the UK would have to withdraw as rapidly as possible from that archipelago, because administering that archipelago was contrary to the right to self-determination of the people of Mauritius. Well, guess what? It took years. It's 3 weeks ago, finally, after pressure, that the UK finally announced that they will now withdraw from the Chagos archipelago. But for me, this is an example where power was at the center of the treatment of this question. You know, Mauritius was lucky that majority of the General Assembly requested an advisory opinion to the ICJ on the question. The position of the UK for decades and decades was to say Chagos is under the sovereignty of the UK, and that there's no way the UK would give it back to Mauritius, because it is simply, without any legal grounds, but just based on power, the territory of the United Kingdom. So power-based international law is another facet, another shade of that selective compliance. Shade number 6, coercive international law. Coercion has become an instrument of the selective compliance. Coercion. I know it might sound weird because coercion in principle is prohibited. But coercion has now become a normal, ordinary instrument of the selective compliance by the Western world, by the global north. What many of these countries like to call sanctions, and sometimes the sanctions are disguised under the more romantic term of countermeasures. What they like to call sanctions or countermeasures is actually most of the time selective compliance with international law. Why? Because sanctions are most of the time reaction by Western countries to political systems that they do not like, cultural systems that they do not like, religious systems that they do not like, economic systems that they do not like. So it is interference with the domaine réservé. It is interference with the domestic jurisdiction of states, which is prohibited by international law. But all these guys, under the necessary responses, necessary countermeasures to so-called illegal actions by other states. So the whole process of coercion, of sanctions, is another facet of selective compliance that we tend to forget when we talk about selective compliance. Shade number 7, deinstitutionalization of the international legal system. That's another facet of the selective compliance. For many of these countries in the Western world to escape the realms of international law, what do? They decided to engage a crusade or to engage attacks against multilateral institutions. The attacks against multilateral institutions, so what I would call the deinstitutionalization, so it's not institutionalization, but deinstitutionalization of the international legal system, is a form of selective compliance, because multilateral organizations, they've been created to actually guarantee supervision of compliance with the rules of international law. So by conducting an attack against those multilateral organizations, you deprive the international legal system from neutral fora that can supervise compliance with the rules of international law. So if you think, for instance, about the whole Trump administration attack against the WTO, the whole weakening of the World Trade Organization, the whole reason behind the whole weakening of the World Trade Organization was to allow the US administration to engage into unilateral trade wars, to engage into unilateral increase of tariffs without any supervision by the World Trade Organization. So deinstitutionalization is another facet of selective compliance. Shade number, I think it's number 8 now. Shade number 8 or facet number 8. Fragmented international law. Fragmented international law, or the fragmentation by the global north of international law. So the questioning of the unity of international law. Compliance with international law requires to ensure the unity of international law. Selective compliance happens when you create fragmentation within the international legal system, within the international legal order. And what we are seeing today are new narratives where Western countries try to present the different fields of international law as self-isolated islands. Also, you have international law and you have self-isolated islands. So this is the strategy that is being put in place to actually engage into selective compliance. That, oh, you know what? The conduct of hostilities is not governed by humanitarian law anymore. The conduct of hostilities is not governed by human rights. The conduct of hostilities is not governed by certain other fundamental principles of international law. So selective compliance is very much based on this fragmentation of international law. That's another facet. And then shade number 9 is what I would call the softization of international law. So turning what used to be hard law into soft law. That's another strategy in the selective compliance. So converting what is hard international law, converting it into soft law, soft international law, to escape the bindingness of rules. The whole interpretation by Western nations of the right to self-defense of Israel is such an example. Is such an example. Right to self-defense is very, very much strictly governed by conditions. The way Israel is doing its so-called self-defense goes outside the strict conditions. But what do we see today is that nation would just talk about the right to self-defense as just something that is there without actually invoking the strict conditions, the hard law conditions that govern the exercise of such a right. They just say it's exercise of self-defense. So it's just like it's something soft that any state could exercise the way it wants. And then last but not least, Madame la Présidente, shade number 10. Shade number 10 of the selective compliance is what I would call the value-oriented international law. Don't get me wrong. I'm not saying that values are not good. Values are important, and it's normal that within the international community we follow certain values. But values are good when they are shared by the international community as a whole. Values are good when they are objective values, when they are values based on peremptory norms of international law, norms of jus cogens. When values become subjective, when values are the values of a group of countries and values that are being imposed, then this becomes a threat to international law. And this is how selective compliance happens, because then you explain your implementation of international law in the lens of your own subjective values. And the values of whom? Who decide what are the right values in the system? This has to be based on a consensus and not on a limited group of countries in the global north who actually today decide what is the good values that international law have to promote and then engage into selective compliance. So this is what I would call the 10 shades. If you allow me, Madame la Présidente, just to conclude on the global implication, because there is the second term of my introductory remarks, which is what are the global implications of that selective compliance. And I will just put it in the discussion and we can come back to that. But for me, there are three types of global implications. First type of global implications is what I would call the structural implications of selective compliance. Structural, why? Because selective compliance is today questioning the very structure of the international legal system. First, no more faith in the rule of international law. Loss of faith in the rule of international law is one of the structural global implications. Then, distortion of customary international law. Selective compliance has led, step by step, to the distortion of what is the customary international law. So, the law that is accepted by the general, constant, and consistent practice of the majority of the member states of the international community. That's another structural implication. And then, a third one, structural implication, the risk of contamination. The risk of having the selective compliance from the West being imported in the global South. That's how it will make its structural implication. Second category of global implications, what I would call conjunctural implications. So the conjuncture, the juncture in which we are, crisis. The selective compliance by the West has led to a crisis. Crisis at three levels. Crisis of multilateralism. There is no longer any trust, any confidence in multilateral processes, multilateral mechanisms, multilateral institutions. That's the crisis of multilateralism. Legitimacy crisis. Yes. the selective compliance has led to a legitimacy crisis, where today, many countries, in particular in the global south, do no longer believe in the rhetorics of international law. Why? Because they believe that international law has lost its legitimacy when it comes to its primary function, which was to achieve solidarity among nations. That's the primary function of international law, achieving solidarity among nations. That's why we talk about the international community. And so today, international law, because of selective compliance, is no longer able to achieve that solidarity. So legitimacy crisis. Why do we even need to talk about international law? And then last but not least, third conjunctural crisis, authority crisis. The selective compliance has led to a crisis of authority in the system. If you think about international peace and security, in accordance with the United Nations Charter, the UN Security Council has the primary responsibility when it comes to the maintenance of international peace and security. What are we seeing today? No more authority for the UN Security Council. You're seeing General Assembly trying to intervene in issues of international peace and security, but you are seeing also more and more regional organizations, trying to be in charge of international peace and security. Very recently, we had the meeting of the Organization of Islamic Cooperation, where the message regarding the issue in Gaza was actually supposed to be a message sent by the UN Security Council, not by a regional organization like OIC. So you have this crisis of authority today in the system. And then I will finish very quickly with the third type of global implications, what I would call systemic implications. Selective compliance has shaken the core foundations of the international legal system. It has shaken the core foundations of the international legal system. What used to be the core irreducible principles of the international legal system is today reducible principles. Peaceful settlement of dispute is being questioned. Prohibition of threat or use of force is being questioned. Prohibition of intervention in the internal affairs of states is being questioned. Sovereign equality of states is being questioned. Self-determination is being questioned. Cooperation in good faith is being questioned. So all those principles that were the core foundations of the international legal system, because of selective compliance, are being shaken down. And then this, of course, questions the very idea, the very existence, and the very sustainability of international law. Thank you very much.
Thank you, Professor, for breaking down the issue and setting the ground for what is meant by selective compliance, including the 10 shades of compliance and the main global implications. I would now like to request Mr. Soofi to shed light on what these compliance issues are for the South Asian region and how have they impacted regional dynamics. Thank you.
Bismillahirrahmanirrahim. Dr. McCain, Maham, Chair of the Board, President, honorable members, ladies and gentlemen, and quite a few law students here today. Assalamu alaikum. Professor McCain's insightful overview of international law, various shades, is an excellent summing up of where international law stands today. And I think I would like to add a shade more, de-emphasizing of international law at appropriate occasions. So if you have UN Security Council resolutions which are standing ground, which have not been rescinded, which have not been recalled, which have not been sidelined or even impliedly repealed by Security Council, simply by de-emphasizing them, we come to a selective use of international law. I'm talking about Kashmir, Professor McCain, in which we have several Chapter 6 and Chapter 7 resolutions for the resolution of the issue of Kashmir, the dispute of Jammu and Kashmir, the issue of disposal of the people of Kashmir and their self-determination, and that entire law comprising of over a dozen UN Security Council resolution that administers that dispute, which was laid down by the Security Council, has been de-emphasized. So it exists on the paper, it exists on the platform, but it stands de-emphasized. No one wants to talk about it. Having said that, the shades that you have talked about bring across a view of international law for young lawyers as if this discipline has a very bad fate that is likely to hit it. Is that so? Well, partly yes, this is a difficult situation, a situation in which we have what is going on in the north with respect to issues in the south and how it has been selectively done. But at the same time, from a South's perspective, I believe the existence of a system, of a global system, howsoever it may be damaged partially in the contemporary times, is important. Its existence is necessary. The mere fact that there are so many multilateral instruments that regulate international affairs, the mere fact that there are so many international institutions, organizations, legal regimes which function, they may not be functioning very smoothly in public international law issues, but then we have private international law bodies which are functioning far more effortlessly and seamlessly between North and South, notwithstanding the various political crises that the global community is looking at. So if you were to look at the transit conventions, laws laid down in private international law matters by entities like ICC, International Chamber of Commerce, by entities like UNCITRAL, UN Commission for International Trade Law, by entities like UNCTAD, UNIDRAW, and several others, the international conventions relating to all those under which the entire global trade takes place, whether it's the Bill of Lading, whether it's Container Convention, whether it's shipping documentation, whether it is letters of credit framework through various banks. So far, so good, touch wood, that's going on smoothly. So there are two levels at which we need to divide our discussion. Level one, public international law, about which 10 shades you have talked about, and I've added an 11th one. But then there is a second tier of international law, which is private international law matters. And these private international law, notwithstanding, as I said, all the disputes, has been functioning, has been going on. So before you come to a judgment that there is no need for international law, I just thought to make you aware that all said and done, existence of these international institutions are nevertheless important from a developing South point of view. Because for certain countries, countries like us, countries in Africa, countries in South America, these standards, howsoever they are carved, shaped, negotiated, written down, are important. That is how we build our argument. That is how we build our state positions around this language, around this text. The text may be partly sidelined, selectively implied, but it exists. It nevertheless tells us that that is where that the legal compass should point towards. So if there is a human rights convention which exists on record, if there are provisions formulated in 1966, whether in the ICCPR or whether in Geneva Conventions, we exactly now have a standard to measure the conduct of certain states. Well, Israel is violating Geneva Convention 4, Geneva Convention 3, article this, article that. There is a very powerful narrative nonetheless, based on which you have door opening to ICJ and so many other venues. So I believe from a certain point of view, there is a need to recognize, strengthen these institutions as much as we can, keeping in view our long-term strategic advantages and keeping in view the consistency and coming together on the table on some of these issues. Just as a pointer, 3 areas in which the North was not interested, but because the South was very, very keen to do a lot of legislative work, international conventions got shaped up. Law of the Sea Convention, one of the negotiators is sitting here. Both of you are sitting here who participated in Law of the Sea Convention's negotiations. US government has been opposing it. The most powerful country in the northern side has been in complete opposition of the whole idea of extending boundaries into sea, whether beyond 3 nautical miles to 12 nautical miles, in exclusive economic zone up to 200 nautical miles, strongly protested. They did not even join the 1982 Law of the Sea Convention. Notwithstanding that, ladies and gentlemen, the southern countries came together and they were able to actually hammer out this convention, which today is the governing law of the seas. Likewise, ICC, International Criminal Court, created by the Rome Statute in 1993, was opposed again by the US and several other northern countries in the northern globe. But again, developing countries came together, and the initiative was led by, you may be friends with Professor Sharif Bisyani, no longer here now, but in the Chicago University, and several other international lawyers coming from developing countries, and they pushed it. And eventually today, ICC is an international body. It may not be able to issue and serve the summons as of now, but the very fact it has processed them, it has identified what are the crimes against humanity and so on, is very refreshing in its own right. We had no other framework to follow. So therefore, I believe that the South still has a lot of opportunities in numerous areas. Climate, we just heard a session before, we're talking about the climate justice and so on, is an issue in which South is coming together to create a noise which has led to a parking of a $100 million fund through which now we can make an effort to reach out to that fund. So while there is a disconnect in Gaza, while there is an issue vis-a-vis Kashmir, while there is a high-end issue relating to Ukraine and Russia, still the international order holds the field. It stands de-emphasized. It stands partially losing its color, it's selectively being used, that notwithstanding. So I think, as of now, where we stand, the cost of selective use of international law is obvious to anyone. And for any man on the street, when I'm stopped personally on streets or when I'm going to the court by fellow lawyers who say, where is the international law that you have been talking about in this country for 30 years? Look what is happening in Gaza, what's happening in Kashmir. I face a difficult time. But having said that, as I said, the environment in which we are today is an environment from which we have to be rebuilt. And now what we are sensing is, Professor McCain, is an alternative legal framework coming through SCO, BRICS and others, which is a very interesting development. So I think instead of weakening the law, it is adding yet another regional tier-minded countries, and that tier will redefine somewhere in the middle where will this law come and hold on to. WTO framework, as you rightly said, was something that is taken advantage of by the China the most. In 1993, around that time frame when it was negotiated, the Chinese lawyers read the treaty and they realized it is giving an unbelievable advantage that you could export things and legally no one can stop you. So they started realigning their manufacturing policy, economic policy, to take advantage of an international treaty this thick, this big, which will not be able to stop legitimate trade that moves out. Hence, now the advantage belongs to them. So there is no other choice left except to de-emphasize WTO in one sense. So I'll, for the time being, stop here. I understand there are a few questions that you have to ask and few questions from the audience. Thank you very much.
Thank you so much, sir, for highlighting some of the successes of international law and also helping us understand the demarcation between public international law, which is a bit more politicized than private international law. Professor Mbengue, I would like to ask you a question before we move on to the audience. So in this era of selective compliance, and you've spoken about the 10 shades and how They've impacted geopolitics as well. Do you think that when it comes to public international law, considering the situation in Palestine and how Israel has reacted to international law, is there any space in the international legal domain that can be captured by the global south in this call for reform of the international legal order?
Thank you very much, Madame la Présidente. Well, I think that for me, I see this era of selective compliance by the West. I see it as an opportunity for the global South in renewing its participation and contribution to the making of international law. You know that quite often international law has been criticized for being of, a European system, a European heritage, because we all know that it was born with the Peace of Westphalia. And you have many scholars from the Global South, many policymakers from the Global South who actually criticize the international legal system for being too Eurocentric. And I think that now that those who have made international law are themselves, departing from it, detaching themselves from it, I think that this is a very great opportunity, great momentum for us as Global South countries to come up with what we believe should be the rule, the principles, the institutions. And so you were saying it in your intervention that we can take advantage as Global South to come with different alternatives, different solutions, and different initiatives. And we are doing so. For instance, right now in the UN, there are discussions, negotiations regarding the right to development. You know that the right to development till now has been only subject to a declaration, the 1986 Declaration to the Right to Development. And we know that we as developing countries, and actually Pakistan has been playing a leadership role on that, because the ambassador who was in charge of the drafting of the text is the ambassador of Pakistan to the UN in Geneva, or Ambassador Akram. Okay. Ambassador Akram. I don't know if he was in Geneva or in New York.
One brother was in Geneva, one.
Yes. So Pakistan has been playing a very important leadership on that, trying to turn the right to development into a binding right. This is what I call, opportunity for the Global South to reshape international law. We need, as Global South, to actually determine what are our priorities. What are our priorities? Our priorities are developmental priorities. Our priorities are security priorities. Our priorities are also environmental priorities. So we should take advantage of this and come up with legal frameworks that reflect our priorities, that reflect our needs. Even if the so-called West is not interested in that. We should not wait, because waiting for them means waiting for the game that they play in selective compliance. So we should not wait. We should just go ahead. The US is doing empty sit. They don't come to the meetings in the UN when we discuss right to development. EU gets there, but to criticize. Good. Let's progress with what is an agenda of the Global South. But I think that what can make us being more efficient, more effective as Global South in this era is much more South-South cooperation. We need more South-South cooperation. I was telling you yesterday that I believe that unity is power. Unity is power. Developing countries and even emerging economies have the same concerns, they have the same history, and so we should be able to come also with a common rhetoric, a common narrative that can allow us to really, shift some of the agenda at the international level.
Thank you, Professor. And I think we're all in total agreement that a reshaping of international law is required, particularly with conversations already happening at international organizations such as the UN and the World Bank. Soofi Sahab, my question to you is that you just spoke about the role that international organizations play in regional dynamics, and particularly with regards to Pakistan and the role that Pakistan can play. What do you think should be the role of international stakeholders, international organizations, and the international civil society in ensuring the reform of the international legal order to one that reflects the realities of the global south more?
Thank you very much. You see, international organizations or international civil society, when you refer, let's be more specific in terms of giving examples. African Society of International Law is an international civil society. Afro-Asian Committee is an international civil society of lawyers. Research Society of International Law is a civil society, and so on. What I'm saying is that when they can have a lot of influence at global lawmaking. They can influence the policy. They can also influence the way international organizations think. And you will understand better that all international organizations, whenever they conduct events, they have special venues, they have special slots for international organizations that are given accreditation by ECOSOC, Economic and Social Council. And there are hundreds of such organizations, some into refugees, some into human rights, some into development, some relating to protection of minors, some relating to labor, some relating to law, some relating to international conventions, and so forth. So these entities which sit behind the states in forums like Geneva, Vienna, and New York are very powerful because their narrative is heard. They are able to, on the sideline, convince even state delegates to come in line with their views. So I think they have a role, and if there are such organizations, they should, people from Pakistan should participate, and they too should coordinate. I mean, for example, we were discussing the African Society of International Law could coordinate. The Hague Academy of International Law, for example, they have a operational arm for young students. Why can't African Society and our society and Hague Academy of International Law conduct some sort of a capacity building work, a periodic series? So that's how you create an influence over a period of time. And another way of doing that is to find an employment in the legal divisions of these international organizations. We have young lawyers sitting here, and you would also know that the legal divisions have an enormous influence in the policy of the secretariat of every organization. So if you are able to find openings in the UN venues relating to international organizations, legal divisions, you will be doing yourself a great service and your country. Remember, in IAEA, International Atomic Energy Agency, 2 lawyers from the legal division rose to become the Director Generals, Mr. Al-Baradi and Mr. Hans Blix. Both were international lawyers from the legal division.
Can I just jump quickly on these excellent ones by Dr. Soofi? I just wanted to add that, the role of the civil society should not just be a passive or behind the doors role. I think that today international diplomacy is becoming more and more expertal diplomacy. Expertal diplomacy, meaning recourse to experts, has become very important in the making, the interpretation, and the application of international law. What has allowed, and let's be frank about it, what has allowed Western countries from the global north to kind of impose some sort of selective compliance with international law is because they claim that they have the best experts. And they claim that they have the experts in the room, while we do not have the experts in the room. It doesn't mean that Global South countries do not have experts. But how do we use those experts? When you go to meetings, for instance, of the Sixth Committee in New York, Sixth Committee is the legal committee in the UN. That's where they discuss, very important issues for the future of international law. For instance, right now they are discussing issues regarding crimes against humanity, a potential future treaty on crimes against humanity. I was talking with my brother here, who was telling me that he's attending meetings of UNCITRAL Working Group 3, where they are discussing the reform of investment arbitration. So you have all those discussions that are taking place that are fundamental for the future of our countries, but that require expertise there. And so South-South solidarity, South-South cooperation should be also solidarity in using experts. Taking the experts of our countries, making sure that they are in the room, that they defend the interest of our countries. That if a US delegate says A, the Pakistani delegate can say B. And if the French delegate says C, the Senegalese delegate will say D. Because we know it as much as them or even better than them. But we need governments in the Global South also to have much more systemic recourse to what I would call expertal diplomacy, because this is how we can bring the voice of the Global South in the making of the future international law.
Thank you, Professor. We have quick 10 minutes for questions from the audience.
Assalamu alaikum.
Assalamu alaikum. Nader al-Turk, Deputy Division Palestine Embassy. Thanks for the speaker for a very rich statement, which giving answers and questions. Actually, I will focus about Gaza, what happened there, genocide, ethnic cleansing, crimes against humanity. It is show clearly the failure of the international system, international law, international organizations. It shows the missing of democracy in the United Nations, especially in the Security Council. When we see, as example, 4 times we go for ceasefire, and the veto of Americans make it fail. On the other hand, the Americans' propaganda speak about protecting civilians in Gaza. We go for the General Assembly United Nations requesting full membership of the State of Palestine, to the United Nations, and the majority of General Assembly agreed of that and sent the request of Palestine membership, full membership to Security Council. About 13 countries agreed of that to make Palestine enjoy full membership. On the other hand, the American veto only makes that dream, that tried, destroyed, and damaged. We will see the second things and third things. I think the United Nations and the international law lose or something missing for it, that it don't have the power to follow up the resolutions, follow up the orders of the law, because there is no fangs and claws for the United Nations. The only power which is follow is the United States of America, according to their own interest. What happened in Iraq, Afghanistan, Gaza right now, Libya, many issues. So, my questions, very simple. How we can protect humanity from such crimes against humanity? What we see in Gaza, but after the failure of the international organization. South-South cooperation is good, but not enough. reform of United Nations is good, but not enough. So what we can do? This is my first question. Second, how we can punish the criminals countries when they are supported by power countries. When I speak about third world facing such thing like this. We are facing battle between logic of power and the power of logic. Israelis, supported by Americans, British, Germans, and other Western countries, and the double standards and all that things, okay? This is power of the logic of power. On the other hand, Palestinians in their rights to struggle for independence, peace, freedom, enjoying their own right, which is waiting and bending since 1947 after 181 resolution. And this is the joke actually, that Israel as a state was establishing by order of international resolution created by United Nations in 1947. On the other hand, Israelis until now not respect and obey any international order or any international resolution. With that, they are still members of the United Nations, which are not obey their orders and their resolution. On the other hand, Palestinians who are the victim of this resolution are still out of the membership of United Nations. So what we can do, what the technique, what the process which we do to be sure that the future of the next generation going to be better, safe, and they are going to be protected from such crimes like this. Thank you very much.
So I think because those were 1-2 questions with them, both of you, one by one. But 2 minutes.
Yes. I mean, thank you so much.
She's saying she can take the question
okay.
and then you can answer. Is that what you're saying? Oh, okay, please. Go on.
Okay. Yes, well, thank you, Ambassador, Excellency. You are almost soon, inshallah. Inshallah. Thank you, Ambassador. Excellency, sorry. But I think that, there were a lot of answers in your questions. It's very hard to, at least, I always like to say that I'm just a humble international lawyer. And law is a tool, is a means, but it's not an end in itself. International law is here as a means, as a tool to build a better world, to strengthen cooperation between nations, but it is not an end by itself. And so when we expect, sometimes when we expect international law to solve all these complex issues that the international community is facing, I think it's sometimes a too optimistic view of what international law can do. Let's not forget that international law at the end of the day is the product of state consent. The international legal system is based on state sovereignty. So the rule of law, the rule of international law can only apply as long as states consent to apply it, consent to play by the rules of the game. This is what the international legal system is about. It's a very primitive system because of this idea of state sovereignty. But for me, what I see when it comes to Gaza, I see that there is resistance, there is resilience, there is recentering from the global south. You have many countries in the global south that are continuing to actually clearly, explicitly emphasize that what is happening in Gaza is contrary to international law. They have not abandoned the narrative of international law. And even in the Western world, you are seeing now divisions based on international law. Because I don't know if you are aware of that, but Norway has a project. I was in New York last week. Norway is preparing a draft request of an advisory opinion regarding the exclusion of the UN United Nations Relief Agency, the legality, UNRWA, the legality of the exclusion of UNRWA by Israel. It's Norway, a member state of the European Union, which is behind such a project. So what we are seeing is that even in the global north, countries that used to be supportive of certain positions today realize that we have reached an extreme situation where if we want to preserve international law, there's a need to save it and to recenter and bring back a resilient discourse on international law. So this is what I'm seeing there. But then, of course, I agree with you that there's a lot of injustices in the system, but they are due to politics. They are due to international politics and not to the content of international law as such, in my view. Thank you.
First of all, Excellency, I would like to, as a member of the human race, apologize to you and through you to the entire people of Palestine, women, children who are left living, and my condolences for those who have received Shahada. It's very embarrassing to address someone like you, given what we have let happen, the entire world. From a purely legal point of view, under the Genocide Convention, Article 1, there is an explicit duty on every state party to Genocide Convention to prevent it. Article 1 is very explicit. Preventing means you can prevent it through diplomatic means, through coercive means, through possible use of force wherever it is possible. So as far as legal obligation on all member states are concerned, who are parties to Genocide Convention, they have a duty to prevent the genocide, and they have failed in their duty. So the failure is attributable to all members of the who are parties to Genocide Convention specifically, and to international community in general. Now, another reason why international community needs to realize, and members of the Genocide Convention and also UN Charter need to realize, is that this is not going to stop with Palestine territory. There's a greater Israel plan owned and announced. So on the basis of historic title, there is an attempted extension of the territories of the neighboring states. So 7 or 8 neighboring states are under the serious threat of losing territory. So all that put together, there is a legal urgency to address the matter of Israel and Palestine.
Thank you, sir. And I just have a follow-up question to that. Sir, you've spoken extensively about the Akhand Bharat situation with India as well. Do you see that there are any parallels between what Israel is doing and what their end goal is, and what India's end goal is, with starting from what they've done in Kashmir to their stance on now the Indus Waters Treaty? So do you see a parallel between the two countries?
Ji Maham, I do clearly see there are only 2 states. All of the states are at the minimum, the common minimum is that we uphold international territories. We uphold international boundaries and boundary territories. So no one is threatening the alteration of those boundaries. Only 2 states have a plan, an announced plan, officially owned. One is unfortunately Israel, the other is India. And both are relying on a historic title, on a historic promise. If this is how it is going to develop, then every country will say, well, people in Senegal will say, people in South Africa will say, well, we owned the entire continent, give it to us. We can say, well, at some point in time, we were completely occupying the entire... So this is going to be an endless and a wasteful debate. And so I think these 2 countries have this. And in this Water Treaty framework, again, you notice, the notice has been served after 5th August 2019 presidential order, because they understand that this territory that they are claiming the title of, that title is obstructed and that title is encumbered because of a treaty which treats another country as an independent state.
That's what I call the risk of contamination, risk of importing selective compliance from the West in the global South. That you will have now some countries in the global South, and I hope not many, that will think that they are entitled to replicate what is happening in the global North. Yeah.
We have time for 2 more questions and we'll take them together. Can we give them, since there's.
Hi everyone.
Okay, sorry, we'll take all the questions together and please keep your questions very brief.
Okay, ma'am.
20 seconds.
My name is Mohammad Umar Farooq and I am a student of law at International Islamic University, Islamabad. My question is from both Professor McCain and Ahmed Biral Soofi. As you discussed, that there is a lot of issue with international law and there is selective compliance. So is it possible and is it a solution that we develop international law for global South that is totally different and international law that deal with global North? If not, what are other reliable solutions? Thank you.
Can we give it to the person, the gentleman in the back, please? Teacher. Iske baad, and then this person, and we'll take all your questions.
My name is Rana Sham and I'm from NAST Law School. Sir, my question to you is that basically the ultimate goal of international law is not just to end the genocide going on in Gaza, but also to end the occupation on the West Bank as well. All right. So we all know the response of the international community over the acts of Israel is that they somehow justified because of the element of armed resistance, and they say that these are acts of terrorism. So basically my question is, since you are an international law expert, do you think that there is some other way which can lead to a two-state solution, which can lead to the occupation finally ending? Or do you think that this armed resistance, it must go on? And we all know that up and until armed resistance will go on, so will Israel's response. Thank you very much, sir.
We can take the question here. Yes.
Yes, thank you so much. First of all, my gratitude to the honorable speakers for the enlightening session. My question concerns the principles of jus cogens and opinio juris in international law. So my question is, in situations where powerful states invoke national security to selectively comply with jus cogens norms, how can international law specifically address the resultant inconsistencies in opinio juris and state practice?
And we have the last question here. This gentleman has had his very big.
Assalamu alaikum. I am Taimur Akbar, a student of law from NAST. I have a very simple question, that is, if UN member countries themselves obstruct the process of law and enforcement of law, then what is the solution regarding these barriers?
So that question is that if the UN member states are themselves curtailing the process of international law, then what is the process? I think it's pertaining to the P5.
Yes, then
majorly,
what
yeah.
are the solutions to these barriers?
Solutions to P5. Okay. They're, yes.
Quickly.
Both speakers, please.
Okay, regarding having a separate international law for global North and global South, not advisable per se, but yes, an alternative law creation actually strengthens the earlier law by reaction. Second point, self-determination or two-state solution. I think this matter needs to be finally resolved. Whether a two-state acceptable solution to both the parties or any other manner, the matter relating to Israel and Palestine needs to be resolved as early as possible in order to ensure that no further genocides are committed. Third, if the UN member countries obstruct, well, there has been a discussion on on creating a membership which is based on more equitable distribution. We don't have a permanent seat of African countries. We don't have a permanent seat of OIC countries. We don't have a permanent seat of several other sectors. So I think at some point that needs to be also addressed so that this inequity is also addressed. Thank you.
Thank you, sir.
Thank you. These are excellent questions, and they could be subject of another presentation. But I know that we have only 2 minutes. But you know, President Erdogan from Turkey, he said at some point that international law has been buried in Gaza. And I was telling myself maybe he meant the international institutional system, the UN, has been buried in Gaza, because I don't think international law has been buried, but the United Nations system definitely, the way it has been conceived in 1945 does no longer, address the needs of the international community in terms of international peace and security. So we need to rethink. We need to rethink. But then, of course, to rethink the whole UN system, you need consensus. And we know that some of the major players there, they would block any real discussions on that. When it comes to the two-state solution, when I hear about the two-state solution, I'm always a bit uncomfortable. Why? Because I believe that it's already solved. For me, there is already a state that is the state of Palestine that is there. So when we talk about the two-state solution, we tend to give the impression that it's still a pending question. Majority of the members of the international community recognize the state of Palestine. Palestine is a non-member state of the UN, is a member state of UNESCO. It's a state. So again, we need to distinguish between international law and international politics. From an international law perspective, Palestine is a state, period. Then the politics of certain states that are playing with that is their politics, but statehood is not subject to recognition. Statehood is not subject to recognition. A state does exist as a state because it fulfills the conditions of a state under international law, and that is the case of Palestine. There's no need for recognition by some countries. So I think we need also, as Global South, to be more bold on using the language of international law when it comes to this issue of statehood, to say that under international law, Palestine is a state, and that recognition or non-recognition does not carry any legal effect at that level. So I will stop there. I'm tempted to talk about the international law for the Global South and for the Global North, but it will be for another episode. Thank you very much.
That brings us to a close to today's session, and over to Tanzila now. Thank you.
Thank you, Maham and worthy speakers. I would request President IPRI to please come on the stage for a quick group photo and present the mementos to the worthy speakers and our moderator. Professor Mbengue to please receive his memento. Mr. Ahmed Bilal Soofi. And our moderator, Ms. Maham Naveed.